Good afternoon or good morning and welcome to the webinar. My name is Matt Kissling. I'm an attorney in Thompson Hine's Labor and Employment Group in the Cleveland office. I'm delighted to introduce two other colleagues that will be presenting with me today, Sarah Flannery and Jason Carruthers, who are also in our labor and employment practice. Sarah's a partner in our Cleveland office specializing in immigration, and Jason is an associate based in our Atlanta office. For the next 90 minutes, we will explore the most recent developments and guidance related to work visas, religion in the workplace, and FLSA compliance and state wage and hour issues. If you are seeking CLE or HRCI credit, please refer to the handout section of your control panel on the screen to access the form. Download the form and follow the instructions to receive credit. Please listen carefully because a lot of attendees may miss this. The GTW control panel is typically located in the upper right-hand corner of your screen. If you do not see it, click the red arrow at the top right of the screen to expand the control panel. This is also where you will be able to submit questions in the chat box. I'll provide the code you need to complete your form at the conclusion of the webinar. Now, due to the large audience we have today and the amount of content we're presenting, we may only have a short time for Q&A at the end. We encourage you to put your questions in the chat box and we will address them with whatever time we have remaining. But please contact your Thompson Hine lawyer with any follow-up questions you may have after today's webinar. Thank you for your interest, and now I'll turn this over to Sarah Flannery, and Sarah will kick off our program today. Sarah?
Thank you, Matt, for the introduction. I practice exclusively within our employment immigration space, and I have been practicing in this area since 2003. And we have seen more change in the last 4 years than we have seen in this space in all of my earlier years combined. I participated in a webinar yesterday that was hosted by the American Immigration Lawyers Association. And in that webinar, there was a fact given of during the Trump administration, there have been 900 new immigration-related policies that have been put in place. So for context on the amount of change that we have seen over the last 4 years, that gives you a data point. The question now is, how many more changes might we see under the Trump administration in the remaining months of their stay in office? And then what changes might a Biden administration bring to the immigration space? We will discuss both some short-term changes that are already in place or will be in place shortly, and then we will also discuss what might be some long-term changes. So in terms of the short term, it has been a very busy Q4 for the Trump administration with regard to immigration. And immigration was a critical piece of Trump's campaign in 2016. Some changes were implemented right away in 2017, and some are coming to fruition now. The new wages, this change impacts H-1B, and I will say that H-1B has been a particular target, especially within the employment-based immigration space. Many of the changes under the Trump administration have been focused on the H-1B visa program. And the H-1B visa program is a work visa that is available to professionals. And we'll dig in a little bit deeper into what roles are eligible for that when we get to the changes on the definition of specialty occupation. With regard to the wages, on October 8th, 2020, with no advance notice, the Department of Labor significantly increased the wages that it requires for H-1B workers. So to provide some background on this, there is a required wage that employers have to pay for H-1B workers. And the reason for that required wage is to protect against foreign nationals driving down US wages. So the big picture view is these are highly sought after roles. These are professional level roles. What the government wants to protect against is companies bringing in foreign national talent, paying them below market, and then having that drive down wages for US workers. So the step that is, or the compliance tool that is in place to prevent against that, is that the Department of Labor requires employers who are sponsoring foreign nationals for H-1B visas to show that they are paying the required wage. The Department of Labor updates the required wage, and it's not one flat wage that is across the board. It is very tailored to what is the occupation and what is the geographical area and what is the level of the role. Is it a entry-level role? Is it a mid-career role? Or is it a senior role? And those wages get updated every July. They were updated in July of 2020, which was 4 months into the pandemic that we're in. And the reason why the 4 months into the pandemic is relevant is that in October, when the DOL increased these wages without notice, the justification for why they were able to do that without notice was, we're in the middle of a pandemic. The pandemic is creating unemployment, and we need to make sure that the H-1B visa program isn't driving down US wages. So what is ironic about that, though, is we were well into the pandemic in July when they updated the wages through the normal process, and those updates in July were very in line with market. The wages that they increased in October are out of line with market. To give some perspective on the wage increase, in Cuyahoga County, the entry wage for a software developer under the July annual revisiting of wages was $54,330. In October, the increase brought the required wage for a software developer in the Cleveland area to $77,626. So this is more than a $20,000 increase. Now, the wage change is being challenged in litigation, and the primary risk that it faces for survival is that it did not go through the normal rulemaking process, that it was announced on October 8th as effective on October 8th. And that is much of the basis for the litigation challenges to it. So we will see if this stays in place. What employers can do as a workaround on this is, you are not restricted to only looking to the wages issued by the DOL when setting the required wage. Employers can point to private surveys, such as those done by like a Watson and Wyatt or other consultants that do wage analyses. So employers can go out and purchase those wage surveys and say, hey, here is what the actual required wage for this role should be in this area, not what the Department of Labor set. And there's several different criteria on what do those wage surveys have to look like, how recent do they have to have been issued, but there is a workaround on this while this remains in play right now. Now, one of the next changes is the change to the definition of specialty occupation. This did undergo the traditional rulemaking process, and it will take place, the new rule will go into effect on December 7th, unless there is an injunction through the courts to it, but it did go through the rulemaking process. So background on what this change is. H-1B eligibility is defined in the law as available to specialty occupation roles. Specialty occupation role is a role that requires specialized knowledge and at least a bachelor degree or the equivalent of a bachelor degree in the specific specialty. Right now, the regs say that the role must require a degree that is related to the role. The new rule narrows that definition, and it's no longer sufficient under the new rule for the degree to be related to the job. It will have to be directly related to the job. To provide some illustration of where this might impact roles, there has been an ongoing challenge over the last 4 years to how the USCIS is adjudicating H-1B petitions for market research analyst roles. These are roles that might be dealing with big data within organizations, looking at what market demand for a product might be. And in order to qualify for these roles, historically, there has been eligibility when showing that the role requires a series of degrees that are somewhat related to each other. Maybe the role requires a degree in business administration, statistics, data management. Under the new rule, that probably would not be approved for H-1B, because under the new rule, the Immigration Service would say, these 3 different degrees that could qualify someone for this role are not directly related to each other. And they're too separated from each other in terms of the knowledge that those degrees instill. So what they want, what the new rule is trying to get to is a more narrow definition of H-1B. So in order for a software developer role to be eligible for H-1B, it's going to have to require a computer science degree, an IT degree. But if it says, oh, and an engineering degree would qualify you as well, that is likely to no longer be approved. Whereas in the past, it would have been able to be approved because you would have been able to show that the engineering degree is closely enough related. So what is the impact of this type of change? It certainly will impact the ability for new H-1B petitions in the future. But the biggest impact of where I think employers would see the most pain is not losing out in the future on being able to bring in certain foreign national talent to certain roles, but perhaps losing the ability to retain foreign national talent that you have already invested in and sponsored maybe year after year for a work visa, because someone with a degree that allowed them to get H-1B under the current rules might not be able to get an extension under the new rules. So it could be a case where someone who has had H-1B with an employer for maybe up to 10 years and the employer has sponsored for a green card and we're just waiting for that green card to come through, that person might not be able to continue to work under H-1B status under these new rules if they do indeed take effect and remain in place. Now, one thing that employers can do and is to look at, well, who do we have currently in our portfolio that might not be able to get an extension under these new rules? And is there a way that we can hurry up and file an extension now before December 7th when the new rules would go into place? That analysis would be looking at what roles are they in, what degree do they have, how closely related is it, and does it make sense to put in an extension, maybe prematurely before it would otherwise be required. Another proposal that came down in October was changes to how H-1B petitions will be selected for review. So again, some background here. There's not enough H-1B visas for the demand. So the Immigration Service every year does a lottery to select which employers can submit petitions for H-1B workers. Right now, the lottery is purely random. The only factor that can increase your odds of selection in the lottery is if the foreign national holds a master level degree from a U.S. university, master's level or higher from a U.S. university, then they do have some priority under the lottery selection. But other than that, it does not matter what the size of the employer is. It does not matter how many years the foreign national has maybe been in the U.S. in another status. It does not matter how much the wage for the role will be. It does not matter what area of work the role is in. What the new rule would do is to prioritize based on the offered salary. And what would end up happening with that is the new rule would, one, favor employers who are perhaps larger employers and in a position to pay higher wages than what is required maybe in order to increase their likelihood of selection in the lottery, whereas a nonprofit might not have that opportunity to consider that as a strategy. And it will also favor more senior level roles because those roles will be paying more than the entry level roles. So it might be the case that petitions for IT managers or senior software developers are going to be selected in the lottery, but those entry-level software developers are not going to be selected in the lottery because they're at the lower wage ladder. One of the risks that this poses is to impact brain drain from U.S. universities. So U.S. universities have seen a drop in international student applications over the last 4 years. And this could further decrease the interest of foreign nationals wanting to pursue degrees at U.S. universities because this limits the pathway to go from that student visa immediately to an H-1B. You might be able to go to an H-1B when you're further into your career, but your first move might not be able to be into H-1B if the selection in the lottery is based on the wage offered for the role. Now, there is some talk within the Biden administration of wanting to perhaps increase the number of H-1Bs that are available in the first place. But there is not clarity on what their position would be on this proposed role for changing how those H-1B petitions are selected. Those are the changes that focus on the H-1B. And, these have been sort of forecasted out as far back as 2017 in the Buy American, Hire American executive order that was issued in April of 2017. And it didn't implement a lot of changes, but it called for there to be changes to the H-1B program. And these are many of those changes now coming into place. There has been an increase in denial rates on H-1Bs even prior to these changes, and there has been a lot of scrutiny over whether or not the correct wage is being paid to the roles. That has been through the discretion that the immigration officers have. These would be changing the actual rules of play, so to speak. Now, on the COVID-based travel bans and limits to employment visas, these are changes that went into place in the spring and summer. And the idea here with the executive orders was, because unemployment in the US is so high due to COVID, we need to restrict the number of foreign national workers that are coming into the US. And so there was an executive order limiting when H-1B visas, L visas could be issued to foreign nationals. There are national interest exceptions that are available to those. And so there are indeed workarounds right now that are already in place. They're not absolute bans, but this would be something that the Biden administration could certainly change immediately because it's an executive order. So that does not require any rulemaking. It does not require any congressional action. It would just be a simple sign of a pen that could remove these bans on the work visas. So far, the only travel ban that the Biden administration has expressly outlined as one that they would want to roll back is the very early Muslim majority country travel ban. So there has not yet been a forecast out from the Biden administration of whether or not they would intend to keep in place some of these COVID-based bans on travel and issuances of visas. These executive orders are in place currently until the end of December. So now if we move to what could be some of the longer term changes that we might see, one that does get a lot of attention in the press is DACA. So the history with DACA was that this is deferred action. This is the group of individuals often referred to as dreamers, individuals who were brought to the US illegally when they were minor children. And the US has been where they have pursued education, they may be serving in the military, and the Obama administration, through executive action, said, we are not going to deport these individuals. It was essentially sort of prosecutorial discretion. We are going to choose to not prioritize these individuals for deportation. And additionally, we are going to give them work authorization. The Trump administration then revoked that policy, and that revocation was challenged in court. And in June of 2020, the Supreme Court blocked the Trump administration attempt to terminate DACA. Now, the court did say that DACA could be rescinded, but the process that was undertaken by the Trump administration didn't comply with what was required, and that there wasn't a full enough analysis. So what will happen with this remains to be seen, but it is something where it was put in place through executive action, and the Supreme Court has stated that executive action, if gone through the right process, would be able to take it away as well. So the Biden administration will be able to act on it through executive action if they do intend to bring that back and allow that to stand. Then another change that would not require any sort of congressional action would be changes within the Department of Homeland Security. Over the last 4 years, there has been a change in terms of the level of scrutiny applied to petitions. There has been a policy change that the reviewing officers will no longer give deference to prior approvals. So if a company secures a work visa for an employee and then 3 years later goes to extend it and everything remains the same, the Trump administration put into place a policy that says we don't give deference to that original approval. So it can be denied at this extension stage. Those are all changes that were within the department and through discretion that is given to the department. So those could all be changed similarly under a new Biden-Harris administration. Some of those changes will help to roll back these processing delays that have been really burdensome for companies. The average processing time for petitions filed with the Immigration Service has increased 101% between 2014 and 2019. Now, the Trump administration only came in 2017, so all of that increase is not at the feet of the Trump administration. But during the Trump administration, there has been really significant changes that have delayed these applications, including the requirement that every employment-based green card applicant has to go for an interview at an immigration office. And scheduling all of those interviews does create delays on petitions. The additional scrutiny, the additional request for evidence delays the petitions, and that would certainly be something that could be rolled back. But in terms of how big of a priority would that be, there's no indication yet. Some other changes, going back to this point on deference to prior petitions, that would be really favorable for employers if there could be the deference to extensions. It gives employers more certainty that once we secure an approval, so long as there aren't material changes, we have the confidence that we can continue to retain this employee and continue to invest in this employee. If every time you need to go for an extension, there's a big question mark around, will it be approved, won't it be approved, it impacts that company's career management for the associate and level of investment in that associate. The Revoke Buy American, Hire American executive order, it was simply an executive order, so it could be reversed very easily, but the real teeth of that are coming out in these changes to regulations, and those are not so easy to reverse. In order to reverse these changes to the wages for H-1B and the definition of specialty occupation, if those do become final rules that stand, you can reverse them by putting in place new rules, but you have to go through the rulemaking process. So you announce the rule, you accept the comments, you respond to the comments, etc. So that would require some time. So those are the look aheads for immigration of where we are right now, what we might face over the next couple of months, and then what might be coming down the pike under a new administration in 2021.
Thank you very much, Sarah. Now we'll be turning to Jason Carruthers in Thompson Hine's Atlanta office. He'll be discussing issues related to religion in the workplace. Jason.
Hey, Matt, thanks for introducing me. I'll just do that again. Hi, I'm Jason Carruthers. I'm out of the Atlanta office, and I'm also an associate in our labor employment group. I think that because Matt and I aren't in the same room, I'll generally just say, hey, we're going to go ahead and move forward to our next slide, and we'll start there. Matt, if you would, could we switch to the next slide? Perfect. So as Matt said, generally what we're going to be covering in this presentation, or at least my portion of this presentation, is federal employment law and religion, and maybe to the extent I have a crystal ball, a little bit of what to expect from the Supreme Court and potential developments in the workplace with regard to religion. But what I think is important before we get into that is to, just at the outset say, if you are a public employer or a governmental employer or perhaps a school, there's a little bit more to the analysis that you're going to want to take into account other than just Title VII and federal employment laws. It's also important to remember that when you're talking about public employees, they have certain First Amendment protections that also might apply to some of the actions that they take at work. Also, it's important to remember that the Religious Freedom and Restoration Act, again, which is something that applies to public employers, is another consideration that you might want to consider if you're a public employer, or perhaps a HR person at a school board or something to that effect, that might need to come into your analysis when you're talking about the appropriate employment actions to take with regard to an individual who's taking conduct that somehow impacts religion or what they say is a sincerely held religious belief. Just to sort of throw some more muck in the system, this presentation is generally directed towards federal employment law. That doesn't mean that your state might not have passed a law that also touches on this particular issue. And that's sort of mirrored with the comparators between the federal Religious Freedom and Restoration Act versus the state comparators. Sort of preparing for this presentation, I went ahead and tried to take a look at who our attendees were, and I saw that we had, people from all over the country, but in particular, if you're in a state like Virginia or Florida or Kentucky or Pennsylvania or Illinois, it's doubly important that, particularly if you're a public employer, that you consider what your state laws might have to say on the particular subject. But with that big windup and that big caveat, I think it's important to talk about the background of where the law is with regard to employment and religion before we talk about some of the changes, so that you'll have some context and some takeaways and a way to sort of interpret what that may or may not mean for your business. So as you can see from the slide, Title VII of the Civil Rights Act generally prohibits discrimination or retaliation against employees because of his or her sincerely held religious belief. Title VII also prohibits discrimination on various other categories, and we'll sort of talk about that a little bit later. But for instance, sex-based discrimination or race-based discrimination are also covered by Title VII. Title VII also protects religious observances as well. So it's sort of no defense to say that although it's okay in our view for employees to hold one particular belief or another, we can't allow them to sort of practice that in a way that would otherwise be accommodated. So if we go back and you sort of look at it, it's a sincerely held religious belief. Now, a sincerely held religious belief is a religious belief that is critical or important in the employee's scheme. So it's not, only this faith or that faith, but if it's really important to the employee in their scheme in a religious sense, then it is a belief that might be protected under Title VII. Now let's go ahead and move to our first hypothetical, Matt. Now, I'm going to go ahead and read this out so we can make sure that we all have the same facts. Hannah is an HR director at a private for-profit company. She is also a devotee of the Shinto faith. Hannah attended a virtual happy hour where she learns that the company's best salesperson is an atheist. She was shocked and really disappointed in the salesperson. The next day, Hannah attended a CLE where she learns about religious discrimination. As soon as she leaves the CLE, she terminates the salesperson because he is an atheist. Hannah is confident that atheism is not a sincerely held religious belief, and the salesperson is employed in an at-will state. So our question is, has Hannah violated Title VII's prohibition against religious discrimination? I'm going to give everybody a couple seconds to pick an answer, or pick the best answer. And I think that we've got a pretty good group, and give everyone a couple more seconds, about 30 seconds, and we'll go ahead and close the poll. Okay, let's go ahead and close the poll, Matt. So it looks like about 80% 80% or so believed that, yes, she did violate Title VII by terminating an employee because he's an atheist, and about 20% did not. So a sincerely held religious belief, as we sort of just discussed, is a belief that is important in the individual's scheme, centrally important to the individual's scheme, and that is sincerely held. It's not going to cover all things, but generally, when the court has answered this question, they're really looking for more of whether an individual sincerely holds that belief, as opposed to going into their doctrinal views or determining whether that belief itself is a religious belief or not a religious belief. Again, when you sort of go back and you look at, in particular, the Supreme Court's precedents on these particular issues, they are very careful not to get involved in doctrinal matters and most likely will err on the side of finding that it is a religious belief. So if you selected no, because atheism is not a religious belief, that's actually probably not the best answer in this case. In fact, there are quite a few Supreme Court cases that stand for the proposition that atheism is protected under Title VII's prohibition against religious discrimination. Let's go ahead and move to our next slide. So again, what Title VII prohibits is discrimination against an individual because of his or her sincerely held religious belief. And when you go here and you look at the slide, I think it's really important to remember that this doesn't necessarily have to apply just to hiring or just to firing or just to benefits. It could really be any term or condition of the individual's employment. So it could be something like, maybe the individual's head covering requirement somehow conflicts or bears on our uniform policy. Or maybe the company's general policy of scheduling everyone to work overtime 2 days out of a week on the weekend might somehow conflict with that individual's sincerely held religious belief or their practice of that religious belief that requires them to observe the Sabbath. So it's, again, in this situation, treating an individual less favorably because of their sincerely held religious belief is generally prohibited by Title VII of the Civil Rights Act. Let's go ahead and move on to the second slide. Now, again, here, typically when we talk about these kind of things, there's various theories. One theory of discrimination is harassment. And in general, when we're talking about harassment in the context of religious-based discrimination, we're talking about a hostile work environment that's created, based on unwelcome conduct that is severe or pervasive. 1 second here. Now, can you hear me?
Yes, we can hear you.
Sorry. I temporarily lost my slide, but now I have it back. So good. So again, unwelcome conduct, like other forms of harassment for our HR people or people who are sort of generally familiar with discrimination law under Title VII, it can take many forms. It could be something like a joke. It could be an offensive display. It could be a threatening or humiliating conduct, or it could certainly be physical conduct as well. Something that's important to realize here, sort of in our changing world where we're sort of moving to a place where, maybe there'll be a lockdown or quarantine or a statewide stay-at-home order, is the way that these offensive displays might come about versus how they might have done that and how they might have happened in the past. So maybe you've got an individual who in the past might have had something up on their laptop or offensive poster on the wall or an offensive picture. But one thing to be on the lookout for now is, with regard to maybe emails and electronic communications that employees are sending out, because again, they're sort of working from home a little bit more often than they had in the past. So that's one point to sort of bring out here. And if you look at the second bullet point, that's really going to be important for our next slide. So religious harassment is actionable where it creates a hostile work environment that is sufficiently severe or pervasive to alter the terms and conditions of employment. So again, one-off conduct is unlikely to be pervasive, and I won't say all but the most extreme, but it'll take some significant conduct for conduct to be seen as severe if it's not as pervasive. So if conduct is severe, so if unwelcome conduct that impacts religion is severe or pervasive, it may give rise to an actionable claim of hostile work environment harassment. Let's go ahead and move forward to our next slide. All right, so we're on our second hypothetical. I'm going to go ahead and read this just like last time. At the end, we'll sort of open the poll for 30 seconds, and then we'll talk about what the best answer is. So here, Carl is a Christian. He serves as a treasurer on his church board. He never misses a Sunday. He never misses Sunday service. And he's also the purchasing manager for a wholesale retailer. Carl has recently started posting non-secular phrases on his door each day, such as "God is watching you." He's also made fun of one of his direct reports, Greg, at a single work function because Greg does not eat pork by calling Greg Mr. Porky. Carl's direct report does not eat pork because of his sincerely held religious beliefs. Carl later issues Greg a written warning for tardiness. Greg complains to Human Resources that Carl has created a hostile work environment based on his religion and brings up the joke he made at the work function. Greg is unaware that Carl has been posting non-secular phrases on his door because he's been working from home. All right, let's go ahead and open the poll and give everybody a chance to vote. And again, the prompt was whether Greg may have a viable hostile work environment claim. And we're going to leave it open for about 2 more seconds. All right, let's go ahead and close and discuss the results. So this one's a little bit closer. Here we've got about 2/3 of the people who believe that Greg may have a viable hostile work environment claim, and about 1/3 who doesn't. And when I go back and revisit this question, I think that the best answer is most likely that Greg does not have a viable hostile work environment claim. But this isn't a situation where Greg necessarily does not have a viable hostile work environment claim. Now let's discuss that a little bit more. Again, what a hostile work environment is for the purposes of Title VII and with regard to religious-based discrimination is generally going to be unwelcome conduct that is so severe or pervasive that it alters the terms and conditions of employment. Now, let's talk a little bit about what severe conduct is or what pervasive conduct is. Now, when you go back and you look at the law, it's going to be squishy. It's not that you make, you make 3 jokes over the course of a week, and if you make the 4th joke, that's going to be what's called to be pervasive. And it's not necessarily that a joke is the kind of thing that's necessarily going to be pervasive, that's going to be severe, although we could certainly imagine things that would definitely push the threshold. I bring that up to say that when we go back and we look at this particular hypothetical, what Greg is complaining of is an isolated, one-off case where there was an off-color joke made at a work function. That's not the kind of thing that necessarily screams pervasive. And also, there's a Seventh Circuit case, which this hypothetical is adapted from, where an individual was regularly called Muhammad Man, and they made fun of the fact that he didn't eat pork, and it wasn't found to be severe or pervasive to support a hostile work environment claim under Title VII. Another thing that's important to see here is, generally, harassment needs to be unwelcome conduct. This could be humiliating conduct. It could be threatening conduct. But when you go back here and you look at the prompt, yes, he complained about it, but do we have facts to sort of suggest that he was humiliated by it or threatened by it? Again, Now, if I was going to sort of talk about this, and I don't want anyone to go home and say, oh, you know, he said you can make all these comments as long as somebody doesn't cry about it or wasn't threatened about it or didn't say that. That's not what we're saying. We're saying that in this case, the best answer is that he probably does not have a viable claim of hostile work environment simply because we just don't have the facts to really sort of fill that out, that he felt threatened or that the conduct was somehow humiliating or that it was, in this case, pervasive. So that's why we're going to go with no as being the best possible answer. Let's go ahead and move on to our next slide. Now, Title VII generally prohibits employers from discriminating against individuals because of one or more protected classes. In this case, we're talking about religion. But Title VII is a little bit different with regard to religious-based discrimination because it actually requires the employer to make a reasonable accommodation for the religious observances of its employees unless doing so would result in an undue hardship. So this is a situation where an employer actually has an affirmative duty to accommodate an individual's observance of their sincerely held religious belief, unless doing so would cause more than a de minimis burden. So generally in these kind of cases, because it's not necessarily evident that an individual holds one religious belief or another, generally the individual needs to notify the employer or his or her employer that they have a sincerely held religious belief and that for one reason or another their observance of that religious belief conflicts with the employer's requirement. A reasonable accommodation could be any number of things. Again, I think we've already talked about a couple of these, but maybe you've got some sort of uniform requirement and you've got an individual who, although you typically require your employers to wear a particular uniform that would conflict with a religious belief, maybe this is an individual who isn't front-facing to the public and it's okay for you to sort of waive that problem or waive that requirement for that individual. What's more likely to be the case is scheduling requests. So maybe you have yourself an individual who can't work on a Saturday or a Friday or a Sunday because one of those days is a day when they need to or when they prefer to go to church or their synagogue or their mosque or their place of worship to observe that. So those are the kind of things that we would think of. You've got an individual who has a stated, sincerely held religious belief. The observance of that somehow conflicts with a work requirement. And there is a way that the employer could accommodate that. But it's important to remember that although the employer does have an obligation to make a reasonable accommodation, all accommodations aren't necessarily reasonable, and some of those would necessarily cause an undue hardship. Now, talking a little bit about the current state of what an undue hardship is, it's generally something that requires the employer to bear more than a de minimis cost. What a de minimis cost is might change based on that particular employer, but generally if it's going to cause them to sort of lose business or make it more expensive to employ that particular individual, or, for instance, maybe you've got an employee who can never work on a particular date and that would require you to hire another employee to allow them to continue to work for you. It's probably going to be more than a de minimis cost, and it's probably not going to be the kind of thing that would be reasonable for the purposes of Title VII religious-based discrimination. So sort of with that foundation, let's go ahead and move on to our next hypothetical. Now, in this case, we've got Eddie employee who is a manager at an exotic rental car agency. Eddie typically works every Sunday starting at 9:30 a.m. Eddie has always attended church on Sundays, even before the pandemic, but now he watches his church's live stream instead of attending in person because of a statewide COVID mitigation measure that no longer allows those things. So the church has recently moved the time for the live stream to begin at 8:45 a.m. and end at 9:15 a.m. In response, Eddie requests to use one of the company's fastest exotic cars, a Lamborghini, so that he can make it to work on time for the start of his shift. If Eddie uses the car every Sunday morning, it prevents the rental car agency from renting one of its most profitable cars on Saturday nights. Would Eddie's requested accommodation constitute an undue hardship? Pick the best answer. And again, for this one, we're just going to leave the poll open for about 30 seconds so that everyone has the opportunity to vote. All right, and we're coming in on time. We're going to close the poll in just a couple of seconds. And let's go ahead and go for it. All right. So in this one, we've got about 70% of the people who believe that the requested accommodation would constitute an undue hardship, and about 30% of the people who disagree. In this case, the best answer is yes, it probably would constitute an undue hardship. Now, in your minds, when you're thinking about this, or at least when the Supreme Court's been talking about this, again, a undue hardship is something that would require more than a de minimis burden, So requiring an employer to incur a loss of profit or the loss of use of one of its most valuable assets, in this case would be the Lamborghini on Saturday nights, so that the individual could come to work, might be an undue hardship. So it's certainly more than a de minimis burden. But although it's not sort of part of this hypothetical, or it wasn't part of our prompt, we also might want to go back and revisit what a reasonable accommodation is. Is it a reasonable accommodation, or would that be the only reasonable accommodation? Now, one, I highly doubt that this would be a reasonable accommodation under most any circumstance. But here, what Eddie seems to be requesting is that he have a fast car so that he can speed to work after he watches a streaming show or a streaming service that might be able to be viewed on multiple devices. So just because Eddie proposes that one possible accommodation, it doesn't necessarily mean that it's the only accommodation. So if we put ourselves in a place and put our thinking hats on, I'm sure we could come up with different ways where Eddie could watch the service, maybe on a different mobile device, or Eddie could maybe request that another manager, stand in for him on Sundays, or, assuming that that individual is willing to do so. Or maybe he could just simply, ask for a scheduling request where instead of them working on Sunday, or Sunday at 9:30, maybe they push it back 5 minutes or 10 minutes. But certainly an accommodation so that Eddie can speed and most likely break the law is not going to be a reasonable accommodation either, although that's not necessarily within the purview of this particular question. But again, because this would be more than a de minimis burden, which would prevent the company from using its property and sort of running its business, the best answer is, again, yes, this is likely to be an undue hardship. Go ahead and move on to our next slide. Okay. So we've got another hypothetical here. Martin is a technician for a tech startup. Martin recently decided to add a signature line with a religious phrase to his internal and external communications. Management believes his email communications, particularly those sent to customers, might be construed as the company's endorsement of Martin's religious views. Does the company have to accommodate Martin's religious beliefs by allowing him to alter his external email communications? Again, let's go ahead and pick the best answer, and we'll hold the poll open for about 30 seconds. Okay, and we're coming up on time. All right, this one we've got a much more definitive response. We've got about 9 out of 10 people who believe that we do not need to accommodate this, and we've got about 10% of people who believe that maybe the company does need to accommodate this. In this particular answer, the best answer is no. The company does not have to accommodate Martin by allowing him to place religious phrases in his communications, particularly with regard to external communications. And this is one of the areas with regard to displays where the courts have been fairly clear. particularly with a communication to the company's clients or the external sort of base for the company, this is not the kind of thing that necessarily needs to be accommodated in that particular way. Let's go ahead and move on to our next slide. And this is probably going to be one that you guys will remember from the news. But again, a store that provides everything a couple could possibly need for a wedding also has a pastry shop. The pastry chef has a sincerely held religious belief that marriage is between a man and a woman. When she receives a cake order from a same-sex couple, she refuses to bake the cake on religious grounds. Does the company have to accommodate her by allowing her to refuse to work? Pick the best answer. All right, and let's go ahead and close our poll. I think we're actually coming up on time, so I'm going to try to speed through some of these hypotheticals. In this particular case, no. The best answer is no. The company does not have to accommodate the employee who is refusing to work. Again, when we think to ourselves, what is a reasonable accommodation? It's not going to be the kind of thing where an employee can just unilaterally refuse to do their particular job, particularly in the context of a for-profit company. So in this particular case, the best answer is no. Let's go ahead and move on to our next slide. Now, with that being said, we've talked about sort of a lot of general rules with regard to religious-based discrimination, but Title VII does have exceptions for religious organizations. So religious organizations are permitted to give employment preference to members of their own faith. Let's talk a little bit more about what a religious organization is. Now, none of these factors is necessarily going to be dispositive or going to be the final word on it. But generally, when we're looking for a religious organization, we're asking ourselves, does the organization have a religious purpose? Is the company's day-to-day operations or day-to-day services religious in origin or religious-based? Is the employer a for-profit organization? So if you sort of look at our first bullet point, although an employer need not be a church or a synagogue to be a religious organization for the purposes of this particular exception, we're going to look at those other factors to sort of determine whether they're a religious organization as well. Again, the religious organization just applies to religious-based discrimination or the preference for individuals based on a particular religion, but it doesn't apply to other forms of discrimination. Let's go ahead and move on to our next slide. And I see that we're coming way over on time, so I'm going to speed through this one and just give you guys sort of the thought on it. Now, this is a situation where you've got a for-profit organization with no religious purpose that attempts to adopt a policy of hiring individuals on the basis of one faith or another. So in this particular situation, what the hypothetical is intended to sort of point out is that this tire manufacturer is not a religious organization. Because they're not a religious organization, based on the fact that we have no facts to suggest that they have a religious purpose or religious-based services, they're not going to fall under that particular protection, and that's likely to be a problem for them. Let's go ahead and move on to our next slide. Now, a subset of our exceptions is the Ministerial Exception. Now, the Ministerial Exception is one that allows only certain employees to be able to bring that prohibits certain employees from bringing different types of discrimination claims, sort of Title VII claims or ADA claims or any claims of that particular nature. So this typically only applies, or at least in the past, it only applied to higher leaders of the church or maybe members of the clergy. Let's go ahead and continue to sort of move forward. And we're going to pass through this hypothetical and the next hypothetical so that we can go ahead and talk a little bit about the Supreme Court. Now, sort of just to close this off and talk a little bit about the Supreme Court, let's go ahead and move on to the next slide with regard to the Ministerial Exception. Now, although the Ministerial Exception does not necessarily apply at this point just to ministers, in the past, that had pretty much been the rule. There was sort of a formulaic rule that if the Ministerial Exception was going to apply, it would only apply to you if you were a minister with training. In 2020, the current court changed that and allowed individuals to sort of take in any number of factors to include individuals that weren't necessarily ministers or leaders of the clergy, and that necessarily probably, or that wouldn't necessarily have been protected under the prior Supreme Court decision. And just for our last slide, let's go ahead and talk about undue hardship. Now, currently the state of the rule is that with regard to undue hardship, it imposes more than a de minimis burden on the employer. Then it constitutes an undue hardship and the accommodation may not be reasonable. But in a recent decision, the court has signaled that they want to go back and revisit whether the de minimis burden is the appropriate burden. In fact, in a concurrence that was joined by Justice Alito, that was written by Justice Alito, and it's already been cited by 3 separate cases across the country, he sort of indicated that we should go back and revisit the de minimis standard, not stating exactly what that standard should be. Also, when you go back and you look at that particular case, what you'll see is that the court also suggested that with regard to accommodations, there might be such a thing as a partial accommodation that could be appropriate in particular circumstances. But with those 2 points, I know I'm going a little bit over on time, and I'm going to switch it over to Matt, but maybe we can discuss additional questions afterwards. Thank you.
Thank you very much, Jason. So I'm going to wrap this up today by talking about everyone's favorite topic, wage and hour in 2020, and specifically, what is new and what can we expect going forward. And there are really 3 different areas I'd like to discuss. First, I'll be providing an update on FLSA compliance issues, what's happened in the past year. Then I'll move over to some important or interesting state wage and hour developments. And finally, we'll talk about President-elect Biden and what we can expect from a wage and hour perspective. So starting off from the FLSA, the first big development we saw dealt with remote working and hours tracking. And this involved Field Assistance Bulletin number 2020-5, which was issued on August 24th of this year. It was issued in direct response to new telework or remote work arrangements that have arisen due to COVID-19, since virtually every office environment is still either working entirely remotely or in some combination of in-office and remote working. The Department of Labor did make it clear that this guidance does apply to all remote working scenarios, so it's going to continue in effect, whenever it is that the COVID-19 pandemic settles down and allows people to return to a more normal working environment. And what the bulletin does is it clarifies an employer's reasonable diligence that's required to determine unscheduled hours worked by non-exempt employees. So basically, what you need to do as an employer to make sure that you're appropriately tracking hours worked by people remotely. So what does the DOL say? They say that first off the bat, that an employer must pay non-exempt employees for all hours worked, where the employer knows or has reason to believe that work is actually being performed. So the key thing to look at here is the has reason to believe. And the DOL says this is essentially a constructive knowledge, where an employer will have this type of knowledge of the unscheduled hours worked if they should have obtained knowledge of those hours through exercising reasonable diligence. The DOL also says that an employer cannot prevent or discourage employees from accurately reporting their hours worked, even if those hours are unscheduled. But the law still does say if someone does work unscheduled hours or overtime hours without approval, they still can be subject to disciplinary action. But as the employer, you will still be required to pay them for that work if you knew or you have reason to believe that the work actually occurred. So the key thing to note here is that the DOL says is that if you've established a reasonable reporting procedure for non-scheduled hours worked, and then you compensate employees for those hours reported, you will be found to have exercised reasonable diligence in trying to uncover those hours worked off schedule. So this is similar to how Title VII treats a sexual harassment reporting procedure, where if you have a reasonable procedure in place, that's going to provide you as an employer a safe harbor from an FLSA perspective for those unscheduled hours worked. And now if an employee fails to use that reporting procedure and you don't otherwise know of the unscheduled hours worked, then as the employer, you're not going to be expected to pay employees for those unreported hours, because you can't pay what you don't know. So if an employee works off the clock, doesn't enter their hours into your system or otherwise report it, and doesn't tell anyone, it's going to be considered non-compensable from an FLSA perspective. Another key thing to remember here is that the employer does not need to go through what the DOL says is impractical efforts to identify unreported hours if the employee fails to use your established procedure. The bulletin itself actually lays out an example involving an employer trying to track employee logins to the computer system through IT records. The DOL says if you otherwise have a reasonable reporting procedure, you don't then need to go through those IT records to try and uncover when employees logged in or logged off and trying to tie that to determine if they actually worked any sort of unscheduled hours. So the takeaway from this is first, it's important to implement and document an accurate and accessible system for remote employees, for all hours worked, whether it's through Chronos or weekly timesheets or something along those lines. Second, you should provide written notification to employees of that system and clearly state your expectation that they report all hours worked. You should remind them that unscheduled hours worked will be paid if reported, but they're required to obtain prior approval before working off schedule. That's a good way to control or prevent employees from working off the clock. You should also clarify that working unapproved off-schedule hours will subject an employee to disciplinary action, and that any unreported off-schedule hours may not be compensated if they don't use your system to report that time worked. So what else do we have from the FLSA and the DOL? There's guidance related to the fluctuating work week, which was a final rule issued on May 20th of 2020. And here the Department of Labor provides clarity on applying a fluctuating work week method for calculating overtime for what we call salary non-exempt employees. So your employees who are non-exempt, but they're paid a set salary as opposed to an hourly rate. And the DOL says you can only use this fluctuating method if that employee is paid a set salary for each week, regardless of the number of hours worked. So if you have non-exempt employees who are all hourly paid, this rule won't apply to you. But something to think about here is, how sure are you that all of your currently salaried exempt employees truly are exempt? And the question is, when was the last time you actually did a classification review to make sure that you're properly slotting your employees into one of the FLSA exempt categories? Because if you're improperly classifying individuals as exempt, that can have significant implications from an overtime perspective, as well as hours tracking and documentation. So for fluctuating work week, what does the DOL say? They say that if you have a salary non-exempt employee who normally works a different number of hours each week, you can determine their quote unquote regular rate as well as their overtime rate based on the actual hours worked in a particular week. You can use this method instead of assigning a weekly salary to a set normal schedule, such as 35 hours or 40 hours. But again, an important thing to remember is that the actual hours worked must actually change from week to week for an employee to be eligible for the fluctuating work week calculation method. The DOL also says that in addition to set salary, you can also pay other incentive compensation to employees, such as bonuses or commissions, stuff like that, and still use the fluctuating work week method. The way you would do this is that you would add any additional compensation paid during that particular week into the calculation of your regular rate. So you take their set salary plus the additional compensation and use the hours worked to determine what their rate would be for that week. So it can be a bit of a confusing concept. So I figured that an example may be the best way to visualize it. So let's look at week one here. Let's say you have an employee who's paid a set salary of $620 per week, but they actually work 48 hours. So you would take these numbers and determine the regular rate by dividing 620 over 48, which gives you $12.92 an hour. You then determine the overtime rate by taking $12.92 times 1/2, or $6.46 per hour. So you determine the total pay by taking $620, the salary, plus that 8 hours times $6.46, which gives you $671.68 in total pay for the week. Now let's look at week 2, where you have an employee who's paid that same salary plus $200 in commissions, and in week 2 they work 45 hours. So here you determine the regular rate by taking 820, so the 620 plus the 200 in commissions, dividing it by 45 hours, and your regular rate is $18.22 per hour. So the overtime premium would be $18.22 times 1/2, or $9.11 an hour. And so the employee's total pay for week 2 is $820 plus 5 hours times $9.11, bringing you to a total pay of $865.55 for week 2. So this is a pretty good visualization as to how this fluctuating work week method would operate. It does require some math, but it can also help you ensure that you're properly paying employees on a weekly basis for overtime hours that they may work. So the next development from DOL deals with joint employer status, and this was a final rule issued in January of this year, where the DOL provides updated guidance on determining joint employer status where an employee performs work for the W-2 employer that also benefits a third-party entity. And what the DOL does is they identify 4 factors for determining joint employer status, as well as some other factors that the DOL says are not relevant. So what are the 4 key factors? First, does the second entity have the ability to hire or fire the employee? In virtually any test where you look at joint employer status, this is always one of the hallmark things that they look for. If that second entity can hire or terminate an employee, they're going to be considered a joint employer. The second factor, does the second entity supervise or control to a substantial degree the employee's work schedule or other conditions of employment? Again, the focus here is on the level of control that non-W-2 entity has over the individuals working for them. The greater the control, the higher likelihood you're going to be a joint employer. Third, does the second entity determine the rate and method of pay? And then fourth, does the second entity maintain the employee's employment records? So the DOL does say that maintaining records alone is not going to justify a joint employer finding. So this fourth element is the least important of the bunch. But the DOL also says to look to other factors that may indicate a significant degree of control over terms and conditions of work. A good example is the Department of Labor's Office of Federal Contract Compliance Programs for government contractors uses a 21-point analysis to determine whether 2 entities are considered an integrated employer. So that's something that the DOL, from a wage and hour perspective, may look to in trying to figure out if joint employment exists. So these are the relevant factors. So what's not relevant? First, whether an employee is economically dependent on the second entity. The second, a contractual agreement requiring the employee to comply with the second entity's legal obligations or health and safety standards. Basically, the contract does not matter. The Department of Labor is going to look at the realities of the relationship between the workers and both of the entities. So along with those lines, it's irrelevant whether a contractual agreement requires quality standards or for the employee's performance. DOL also says that an existence of a franchise or franchisee relationship really doesn't matter. So entities like McDonald's or Burger King who sell franchises, they're not going to be considered employees of franchises workers simply because McDonald's issued the franchisee agreement. And finally, DOL says that the second entity, it's not irrelevant. The second entity provides the W-2 employer with a sample handbook or employment forms, or jointly participates in health or retirement plans. So some other things to note for joint employer status. First, a shared services arrangement is usually sufficient to establish joint employer status. So if you share HR, legal, or financial functions across organizations, typically where a percentage of an employee's pay is allocated to each organization. Joint employer status will also exist if both entities share control of the employee, either directly or indirectly. And finally, if joint employer status exists, you must aggregate all hours worked for both entities in determining whether any overtime is required for a particular week. So you're not going to look at overtime separately for each organization. You need to look at the total hours worked by an employee across all organizations. So again, to kind of visualize things, here's a good example. So a tool manufacturer contracts with a cleaning company to provide weekly sanitation and deep clean services for COVID-19 prevention. Now, the contract doesn't give the manufacturer any authority to hire or fire the cleaning company's employees or to supervise their work. But in reality, the manufacturer's HSE supervisor oversees the work performed by the cleaning company's employees and specifically assigns them tasks at the facility, as well as areas to sanitize, provides instructions on proper cleaning of machinery, and keeps records of hours worked to send to the cleaning company. And there have also been situations where the manufacturer has been unhappy with the performance of several workers and has requested that the cleaning company terminate or discipline them, and each time the cleaning company agreed. So what's the result here? So the Department of Labor says in that situation, the tool manufacturer will be considered a joint employer of the cleaning company's employees. So why is this the case? Most importantly, the manufacturer's HSE supervisor actually oversees the work being performed and assigns tasks to perform. That individual also provides specific instructions on how to clean equipment. And to a lesser degree of importance, the supervisor does track and record hours worked by each of the employees. And then the manufacturer requests that certain workers be terminated due to performance, and the cleaning company always complies. So just one of the key takeaways from this is that the focus is on the actual relationship between the manufacturer and the cleaning workers, and not the terms of the contract between the manufacturer and the cleaning company. So the final big update that we saw from the Department of Labor this year deals with independent contractor determinations. This involves a proposed rule that was issued on September 22nd, where DOL proposes to adopt an economic reality test to determine employee versus independent contractor status, where the key inquiry is going to be, is the worker economically dependent on that potential employer for work? And the rule also establishes core factors as well as other considerations for making that economic reality determination. So the two core factors look at the nature and degree of a worker's control over the work being performed. And then the second is the worker's opportunity for profit or loss based on initiative and other investment. So some other things the DOL may look at is the amount of skill required for the work, where typically the higher level of skill required, the more likely that could favor an independent contractor relationship. The degree of permanence of the relationship between the worker and the entity. So if it's a relationship of an indefinite term, that could signal more of an at-will employment relationship as opposed to a set duration for the relationship. And also whether work is separate or part of an integrated unit of production. So if the work is separate from the normal business or constitutes a special project, that's going to increase the chances of that relationship being found to be a 1099 or independent contractor situation. So the big catch here is that this rule is still in the proposed state, where the public comment period ended on October 23rd, and no final rule has been issued yet by the Department of Labor. So why is this important? Is that the tea leaves say is that this rule is likely to be withdrawn or revoked under the Biden administration. Instead, after January 20th, 21, the Department of Labor may seek to expand the definition of an employee for FLSA purposes to make it harder to classify workers as independent contractors and avoid everything that goes along with an employer-employee relationship. So that's those are the big ticket items from the federal level. Let's look at some recent state law developments, that may be important to your business. So first, and everyone's favorite state for wage and hour issues is California, where their SB 973 was signed into law on September 30th. And what this says is that beginning in 2021, California employers with at least 100 employees must submit annual pay data reports to California's Department of Fair Employment and Housing. Now, these reports are nearly identical to the now retired federal EEO1 Component 2 reports from 2017 and 2018, which I'm sure for a lot of you create a lot of headaches in September of 2019 in trying to put those reports together and get them filed by the deadline. Well, in California, in 2021, employers are going to be required to report W-2 earnings and hours worked for each of their California employees, broken out by EEO1 job group for a pay period between October 1st and December 31st of the prior year. And again, I mentioned that the first deadline is March 31st of 2021. This will cover data from the 2020 payroll period. Really kind of the thought process here was that, California, as well as a number, of other Democratic heavy states were unhappy that the EEOC revoked the federal component to reports. And so they decided to enact their own reporting requirements in an ongoing effort to combat compensation discrimination in the workplace. So shifting to from the West Coast to the East Coast, let's look at New Jersey. So, a couple of big things here. First was Assembly Bill 5838 issued in January. So this authorizes the New Jersey Department of Labor to issue stop work orders to any business location that's found to be in violation of their state wage payment laws, including issues related to employee misclassification. So misclassified employees can have consequences at both the federal level and the state level. And in New Jersey, you can actually be ordered to cease work until you come into compliance. And businesses will be fined $5,000 for each day they operate in violation of a stop work order. And that moves us to Assembly Bill 5840, which expands the joint and several liability for New Jersey wage and hour violations to owners, directors, officers, and managers of employers. So the scary thing here is that individual liability not only exists in many states for discrimination issues, but also for wage and hour violations. And another thing to think about in New Jersey, if you're not familiar with their laws and you have operations there, is unlike the federal level, New Jersey has a 6-year look back period for wage and hour violations versus the 2 years from the FLSA. So if you're in New Jersey, it's important that you make sure you're compliant from a wage and hour perspective. And just one other thing in New Jersey, this was issued or passed on January 21st, that the New Jersey WARN Act now requires 90 days advance notice of a plant closing or mass layoff. But more importantly, it also requires employers to provide a severance pay to discharged workers equal to 1 week of pay for each full year of employment. And if less than 90 days of notice is given, then employers must give an additional 4 weeks of severance to each impacted employee. So going to the next state over from New Jersey and New York, some things to note here is that effective in January, the state increased their minimum exempt salary thresholds for the administrative and executive exemptions under New York law. So for New York City, an employee must make at least $1,125 per week, or right around $59,000 a year to be exempt. In Nassau, Suffolk, and Westchester, it drops down to $975 per week. And for the remainder of the state, it's $885 per week. So again, these were the exemption thresholds for 2020. We expect these to go up again coming into the new year. So that is something, if you have New York operations, to keep in mind. Some other big developments that we've seen from the state level deal with paid sick leave. As you know, a number of states and municipalities over the last 5 years have put these kinds of paid sick leave laws in place, which typically require paid leave for an employee's own illness or injury, or for an employee to seek medical care, as well as an illness or injury of a family member, and then also for certain reasons related to school closures, ironically due to public health emergencies, as well as certain issues related to domestic violence, stalking, or sexual assault. So one of the biggest developments in 2020 was in New York, where their paid sick leave law took effect on September 30th. It provides mandatory sick leave across the state based on employer size. So if you have at least 100 employees in the state, you need to give up to 56 hours of paid leave per year. If you're between 5 and 99 employees, that's 40 hours. And if you're less than 5 employees, up to 40 hours of paid or unpaid leave per year, depending on the annual net income of your business, which I believe the threshold is about $1.5 million. So even if you have less than 5 employees, if you make more than $1.5 million in a year from a net income perspective, you'll still need to provide paid leave. And then leave is accrued at the rate of 1 hour for every 30 hours worked. And the accrual began on September 30th, and employees will become eligible to use the accrued leave beginning on January 1st of 2021. So another state that's rolled out paid sick leave law is Colorado, where beginning on January 1st, it applies to private employers with at least 16 employees. And then beginning on January 1st of 2022, will apply to all private employers in Colorado, regardless of size. And in Colorado, you must provide 1 hour paid sick leave for every 30 hours worked, up to a maximum of 48 hours per year. And the leave can be used for the reasons I described previously, for illness or injury of an employer or family member, as well as reasons related to domestic abuse, sexual assault, or harassment. And finally, Maine has a law that's going on the books effective January 1st of 2021. And this applies to employers with more than 10 employees in the state. And here you must provide 1 hour paid leave for every 40 hours worked, up to a maximum of 40 hours per year. The interesting thing about Maine is that the paid leave can be used for any reason and is not limited to illness or injury. So it's just a general paid leave requirement for employees. So the sense is that this is the state's attempt to require employers who may not provide paid vacation to provide some sort of paid time off to their employees on an annual basis. So obviously, with these state law developments, most of these laws do create an exception that if you already have an existing vacation or PTO policy in place that provides the required amount of leave in the state and meets the other requirements for use of that leave, including carryover of unused leave into the new year, you don't need to roll out any new sick leave or paid leave programs. If your existing program already covers all your bases, then you're set and you don't need to do anything further. So that takes us to the next development from a statewide perspective, which deals with salary history bans, which, as you may know, these typically prohibit an employer from asking about or relying upon an employee's prior salary in making an employment decision. The big caveat to that is that you are still allowed to ask an employee's salary expectations. You just can't ask them what they're making in their current job or their prior job, on an application or during an interview. Or if an employee volunteers that information, you're really not supposed to use it then either as part of your decision-making process. So the big ones that have been rolled out this year were Cincinnati, Ohio. So anyone who has employees in the city. Similarly in Toledo, became effective June 20th. Philadelphia, enforcement began on September 1st, 2020. The law had been on the books for a while, but now they're beginning to enforce it. The state of Maryland had rolled one out on October 1st, and Colorado has one that's going to become effective on January 1st of 2021. So a few other points on state wage and hour issues deal with COVID-19 specifically and some things to consider. The first thing to think about when you're trying to navigate the complexities of COVID-19 in the workplace are state meal and rest break requirements, where many state laws do require meal breaks regardless of whether employees are working on-site or remotely. And a number of states actually have specific requirements on the timing of those breaks. For example, in Illinois, a 20-minute meal break needs to be taken no later than 5 hours after beginning work. In Kentucky, you need to provide a reasonable lunch period. They don't define a specific time, but it needs to occur between 3 hours and 5 hours after starting a shift. And in New York, a 30-minute meal break needs to occur between 11 a.m. and 2 o'clock p.m. So what are the things you need to be thinking about here? So, if you've rolled out staggered meal periods, in an effort to reduce contact between employees on site, are you making sure that those staggered meal periods, meet these particular timing requirements? And if any of those staggered periods fall outside the required window, then you may need to go back and adjust how you're staggering periods to make sure you're not inadvertently teeing up a wage and hour complaint or a state Department of Labor investigation. Another thing to think about are what steps are you taking to ensure that remote workers are actually taking their meal breaks? A lot of these states laws say that meal periods cannot be waived or foregone by an employee, that they need to be taking these meal breaks and they need to be excused from doing work during that break period. So this goes back to what we talked about at the beginning and the importance of having a procedure in place to track hours for employees. And by having that required system in place, you're tracking and making sure that employees are logging in or logging out or recording their unpaid meal periods. So another thing to think about are state call-in pay requirements. We're currently 8 states plus DC have call-in or reporting time pay requirements. This is where if an employer reports to work for a scheduled shift, but is sent home before completing that shift, they must be paid a minimum amount. In New York, it's up to 4 hours at the state minimum wage, and in California, it's at least 2 hours, but no more than 4 hours at an employee's regular rate. So the thing to consider here is, do you screen employee temperatures or require health questionnaires before entering the facility? So if you have employees who show up to work and get turned away because they have a fever when you screen their temperature, they're going to need to be paid for that call-in period. Them reporting to work is going to be considered call-in time, and they'll need to be compensated accordingly. The same goes if you send employees home to a positive shift or a positive test before their shift ends. So I know we're right at the end of the presentation, but I just wanted to quickly touch upon President-elect Biden and what this could mean for wage and hour law. Really looking at the magic 8 ball right now. So first, from an FLSA perspective, again, I mentioned before that the Department of Labor's current independent contractor proposed rule is likely to be revoked or rescinded. If it stays at a proposed rule stage, it can just be revoked by the new administration. If it goes to a final rule, then it'll need to be revoked through regulatory action. Another thing to think about is a potential increase in the minimum salary threshold for the exemption under the FLSA. It's currently $684 per week. And the thing to remember here is that the Obama administration had attempted to increase the threshold to a whopping $913 per week, or roughly $47,500 per year, before a federal court said that the Department of Labor exceeded their authority in doing so. But that doesn't mean that a Biden administration could raise the threshold to say $750 or $800 per week, which could decrease the number of employees on your payroll that would be considered exempt from a salary perspective. Another thing we could see from the Biden administration is something that was on his campaign platform, was striving for a $15 minimum wage. He's also expressed an interest in trying to eliminate the tip credit, a reduced minimum wage for hospitality or restaurant workers. That's something that could require an act of Congress and would likely meet some resistance. Another big thing that we expect to come back are the federal EEO-1 pay data reports. So what I was talking about in California before, it could be coming back from a federal level, where all employers with at least 100 employees will be required to annually report W-2 wages and hours work data in conjunction with EEO-1 reports. Consistently across the board in the industry, this is one of the big items that everyone's saying that Biden is going to try and bring back pretty quickly once he takes office. Another thing that we could see movement on is federal paid leave. Currently, only federal contractors and subcontractors are required to provide leave for certain situations under Executive Order 13706. And Biden's platform is to grant all workers 12 weeks of paid leave for a serious health condition of a worker or family, basically making FMLA, 12 weeks of FMLA paid as opposed to unpaid. The big catch here is that this would require legislation passed through Congress. And so, this is really another area where the Georgia Senate runoffs in January are going to determine whether this 12 weeks of paid leave becomes a reality for private employers in the workplace. So even if the Senate does not switch parties, there's still some catches. Federal contractors beware. So President-elect Biden can impose a number of wage and hour requirements on contractors and subcontractors through executive order, where they basically make compliance with the requirements a condition for an award of a federal government contract. And they could also impose mandatory flow-down obligations to subcontractors that are supporting that federal contract. So again, here are the potential targets: $15 minimum wage. The current threshold for contractors is $10.10 an hour. What the Biden administration describes family-sustaining benefits for employees. So basically providing health insurance and other types of benefits. It could also involve some sort of paid leave, paid family and medical leave programs. And finally, compensation data reporting outside of what contractors are required to report during a normal OFCCP audit. So I know that was a lot of information. We went over, over the time by a few minutes, but If you have any questions after today's presentation, please do, call your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, please contact one of us and we can discuss available options to address your needs. And if you would like to receive CLE or HR CI credit, the code for today's webinar is Top Topics 2020, which is listed on the screen. And you can retrieve the form from the handout section of the GoToWebinar control panel, which is again up in the right-hand corner of your screen. And we hope that you will also take a moment to complete a short evaluation of today's webinar. So on behalf of Jason and Sarah, I would like to thank all of you for attending today. And again, if you have any questions, please don't hesitate to reach out to any of us or contact your normal Thompson Hine lawyer. So with that, I hope everyone stays well and have a great rest of your day.